Good morning, everyone. Thank you so much for joining the Housing Right to Counsel training. We are excited to have those of you who are able to attend in person and those who are attending virtually. Excuse me. My name is Elena Bowers. I am a supervising attorney at the Legal Aid Society of Legal Aid DC, excuse me. And we are excited to have you all here today. The Housing Right to Counsel Project is a joint venture of Legal Aid, Bread for the City, the DC Bar Pro Bono Center, Legal Counsel for the Elderly, Rising for Justice, and the Neighborhood Legal Services Program. And you will have trainers today from all of these wonderful organizations talking to you about how to handle these cases. So first, welcome. A little bit of background on what the Housing Right to Counsel Project is. What we focus on is placing eviction matters where a tenant has a subsidized unit with pro bono counsel with the goal of increasing tenant representation in eviction matters. And our underlying goal is to preserve subsidized housing for people who are lucky enough to have it, or who are fortunate enough to have it in this increasingly unaffordable city. And one of the best ways to preserve subsidized housing is to prevent evictions in the first place. And the way that the project works is we send a number of letters guaranteeing counsel to people who have subsidies in eviction proceedings. When people contact us seeking an attorney, we place those cases with pro bono attorneys from your wonderful law firms. Welcome. Thank you so much. There's a handout with our slides as well. And you all at your firms have a wealth of internal knowledge from the number of cases that your firms are taking, as well as mentors from the legal services organizations that you partner with. And then there are a bank of resources available, as well as resources that your mentor can provide directly. In taking on these cases, it's important to understand the client population that we work with. As probably most folks, both online and in the room, know, poverty in DC is a huge and systemic problem. 1 in 6 residents in DC live in poverty, and that includes 1 in 4 children live in poverty. East of the Anacostia River, 1 in 3 residents live in poverty, over half of whom live in deep poverty. And so when we're taking these cases, it's very important to consider your client's background and the daily challenges that your clients face, in addition to the eviction case that you're helping them with. There's little to no, clients might have very little or no income whatsoever. They may have little or no experience with lawyers. They may have only negative experiences, frankly, with lawyers. They may have health conditions or past trauma that they don't have the resources to adequately treat, and there are competing demands on their time and whatever income they do have. So as we approach these cases, it's important to take a client-centered approach in our client counseling, both how we talk to them about the facts of their case and sort of how we counsel them on their legal options. It's very important to empower our clients' voices in the legal process in their cases, and to work with them with empathy and respect for the difficult challenges, the difficult choices that they make in the case. Your representation might require difficult conversations with your client, including intimate personal details, unreported income, sort of other things that feel shameful or can be associated with shame. And it can be really difficult to create that relationship without sort of a lot of work on your side. So it's important to wait to build trust before having these sensitive conversations, and keep our own personal value judgments in check, because we don't fully understand what our clients are living day to day. Now, this program focuses on placing eviction matters in subsidized cases. And so there are 3 main housing subsidies that this project works with: public housing, site-based or project-based Section 8, and the Housing Choice Voucher Program. And we will go significantly into more detail about these properties or these types of subsidies in the coming hours. So first, what is public housing? The DC Housing Authority owns and typically manages the property. There are private managers at some DCHA owned sites, and there are also private managers at some redeveloped sites that are called Hope 6 or something like that, but they're owned by the DC government, the DC Housing Authority. HUD provides the funding to DCHA, large annual payments, and there's no specific contract rent amount that we know of. There are federal and local regulations governing these properties, and that govern the rights of the tenants in these properties, of course. And so it's important to begin your research in the federal and local regs. There are standard leases. These properties are these subsidies are largely tied to the property. They're only semi-portable. They have the right to transfer to different public housing properties in case the conditions are incredibly bad or in case there's some sort of other emergency, but that right can be incredibly hard to actualize. And they recertify with DCHA site manager on site, so there's someone on site that can process the recertifications. The next large chunk is site-based or project-based Section 8. These units the subsidy is tied to the property and the unit. They're owned and operated by private landlords who contract individually with HUD. Each unit has a particular contract rent, but the tenant pays their rent based on their income. And HUD pays the balance to the landlord. They're governed by federal regulations only. There are no different local regulations that govern these properties. And the best guidance is found in what is colloquially known as the multifamily handbook. The citation is here. They're not portable. Theoretically, you can transfer within the same property or a right to transfer between properties owned by the same landlord. Even in cases of extreme domestic violence, I've never seen this actualize. These tenants will recertify on site with a property manager at the rental office. And the last big bucket, yes. So we don't talk about the low income house LIHTC colloquially in depth. While LIHTC might be at play in some of these cases, LIHTC is not a subsidy that's based on a tenant's income. And so we don't consider it a permanent subsidy for purposes of placing these cases. So the cases that are placed through the Housing Rights Counsel Project will have some other subsidy. Sometimes there's LIHTC also, which can be tricky to figure out, and your mentor can sort of help talk you through. But for the most part, the programs that we're talking about today sort of encompass all the rights that LIHTC tenants have, and frankly, usually more. So the third large subsidy type that we're talking about is the voucher program, Section 8 vouchers. And this is where a tenant contracts with a private landlord and the private landlord contracts with DCHA. And it allows tenants to choose among private landlords or use their subsidy to rent a market rate unit. So there's a lease between the tenant and the landlord, and there's a housing assistance payment contract or a HAP contract between the landlord and DCHA. The vouchers are administered as a public benefit program by DCHA, also governed by both federal and local regulations. They're portable. You can use them at any market rate unit in DC, excuse me. You can also port them outside of the district, mostly. They would be recertifying with DCHA at the 300 7th Street address. And there can be a lot of obstacles to voucher utilization in DC. The maximum rents, well, there's some changes in this that we can talk about, but the utility of vouchers can be really challenging, and DCHA has a lot of processing issues. So we often work with our clients to help them move when that's necessary. Practice tip. So one of the first things that you'll have to do is be sure you know what program it is. It will largely be included in the materials that we send over, but it should always be on the top of your mind, because as you'll see, sometimes it can be hard to correctly pin down what the subsidy type is. So if the landlord is DCHA, it will always be public housing. If it's a private landlord, it'll usually be site-based Section 8 or the Housing Choice Voucher Program. Sometimes privately managed companies will be public housing properties. So it's helpful to know where your client recertifies and how often your client recertifies. And the utility of going through these today is not so that you all have them immediately memorized, but that you can sort of spot the key issues and you remember to ask the key questions and focus in on the key questions. So if they certify at the rental office every year, it'll be site-based Section 8. If it's at DCHA every 2 or 3 years, it'll be the voucher program. And if it's at the rental office every 2 years, it'll likely be public housing. Really mean I didn't break it, but so it's important during the course of your representation of your client, they might need to recertify. Recertifying makes sure that the rent is appropriately tied to their income amount and their household composition. So there are regular recertifications that are required by the program, but your tenant could have additional requirements to recertify when they lose income, when there are other major household change compositions. And so they will need to provide there will be times where your clients will need to affirmatively provide information outside of their regular recertification. Failing to recertify can vary depending on the program. In public housing, it starts the process towards an eviction case. I don't think we're seeing a lot of those yet. In site-based Section 8, it can also start the process towards an eviction case, or they can switch over to market rent, which will start a non-payment of rent case in most cases. And in the voucher program, it can result in termination of their subsidy. And so that's one of the reasons it's important to continue to work with our clients on these. Okay. Next slide. Thank you. So if your client ever tells you, I lost my job, my son moved out, I got a divorce, anything like that, you'll want to tell your client to report income decreases and changes in their household composition right away. So if they lose their job on the 29th of the month and they notify their property manager on the 30th of the month, it should be in effect for the next month. If they wait until the 1st or 2nd or 5th or a few months later, it will not go back and be retroactive. Whether that someone is required to report an income increase varies, and so be sure to check the regulations before you tell your client to go tell them that they now make more money. Next slide. Oh, thank you. So other ways to figure out what type of program it is, it's helpful to know if the subsidy is tied to the unit, or if your client thinks that they're able to move, if your client has a relationship with DCHA. These are all ways to sort of narrow in the issue of what type of subsidy it is and which is important because it's sort of what rights and remedies they might have in their case. Before we move on to the next slide or next section, does anyone have questions about sort of the 10,000-foot overview? We will likely answer them, but just in case. Okay. Now I'm welcoming my colleague from NLSP, Adam Marshall. Sure.
Good morning, everyone. My name is Adam Marshall. I am the managing attorney of the housing unit at Neighborhood Legal Services Program, one of the other participants in the Right to Counsel Project. And for this section, Elena and I are two most common types of eviction cases in DC. So the vast majority of cases are non-payment of rent cases. I believe over 95% of all cases filed in the landlord-tenant branch are non-payment of rent. The next most common type of case is a case for violation of obligations of tenancy, lease violation case, also called a notice to quit case. Next slide. DC is a for cause or just cause jurisdiction. That means there are no fault evictions in DC like there are in many other jurisdictions in the US. All grounds for eviction are enumerated in DC. So a landlord can only sue to evict a tenant based on limited reasons. And those limited reasons are based in the Rental Housing Act, which is codified at Title 42 of DC Code, Section 3505, and subsequent sections. A landlord cannot evict a tenant simply because the lease has expired. Any expired lease in DC automatically converts under the Rental Housing Act to a month-to-month tenancy with the same terms. There are also no self-help evictions in DC, so a landlord cannot change the locks. They cannot, use any non-judicial means to regain possession of the unit. They can only regain possession through court process, through obtaining a judgment and then executing the judgment by the U.S. Marshals. Next slide. So going into the elements of making out a cause of action for non-payment of rent, which, like we said, is the single most common type of case in DC. So a landlord's prima facie case includes the existence of a landlord-tenant relationship. And in the vast majority of cases, especially subsidized cases, this will be shown through the existence of a lease, but it's not strictly necessary to establish a landlord-tenant relationship. There also needs to be proof that a legally sufficient notice to quit or notice of past due rent has been properly served. The statutes and regulations previously allowed the waiver of this notice in non-payment cases in the vast majority of cases, except for in public housing. That has since been changed by legislation a few years ago. So there's no waiver of this notice period that's allowed under current legislation. The final element of the landlord's prima facie case in a non-payment case is proof that rent is owed. Usually this will be accomplished through a rental ledger, and new filing requirements actually require that a copy of a ledger or ledger equivalent going back to zero balance be served to the tenant along with the notice and along with the complaint. Finally, that balance must be at least $600. Again, this is under part of the suite of new legislation that went into effect a few years ago.
Of course, there are defenses to these causes of actions, and that's why it's so important for all tenants to have representation in these cases. So first, the number one defense that we see in non-payment cases is that there was a breach of the warranty of habitability. There's an implied warranty of habitability in every lease in the district through case law and within the regulations. And in order to assert this or prove this, you need to show the period of time that the conditions were in existence, that the condition constituted a violation of the housing code or the property maintenance code. The landlord knew or reasonably should have known about the condition. They failed to repair the condition within a reasonable time, and the impact of the condition on the tenant's use and enjoyment of the premises. And the tenant has the burden, of course, of proving the extent by which the value of the premise was decreased based on the conditions. Next slide. Void lease. This is one we don't use very often, but you can ask that the court declare the lease void ab initio at the time of filing and confer no benefit on the landlord. And then there would be a requirement that the property establish what the fair use and occupancy value of the unit is. You need to prove that the condition existed either at the inception or after the inception of the tenancy, the period of time of the conditions made the premises unsafe and unsanitary. The landlord knew about the condition and the landlord failed to repair. Before you raise this defense, please talk to your mentor about whether it is a good idea. But the burden then does shift to the landlord to prove the value of the premises. If there have been prior judgments or prior settlement agreements, this defense wouldn't work. Next slide. Another one that we see frequently is retaliation. The claim that the suit is retaliation to punish the tenant for an assertion of their rights. And the statute and regulation refer to actions not otherwise permitted by law, but the DC Court of Appeals has interpreted it to cover otherwise lawful actions like filing non-payment of rent cases. New regulations specify that retaliation involves a landlord acting. Thank you.
Are we back?
We're back.
We are so back. All right. Next defense, constructive eviction. So constructive eviction is like void lease, a less common defense. The threshold for proving constructive eviction is quite high. What is required is proof that the consideration for the rent, the use and occupancy of the premises has completely failed, that the premises are wholly uninhabitable. You need to prove that the premises have become uninhabitable through acts or omissions by the landlord, and you need to prove that the tenant actually did vacate the premises because of those acts and omissions by the landlord that caused the consideration to fail. Other defenses. A tenant can contest the amount of rent that is pled in the complaint. In a subsidized tenancy in particular, a tenant can argue that there's some miscalculation of their tenant portion based on the recertification. In a rent-controlled unit, tenants can argue that the rent level is illegal under DC's rent stabilization law. A tenant can argue that a landlord has converted other fees such as utilities or late fees into rent, and the law does treat them differently. A tenant can also argue that the landlord is trying to seek legal or attorney's fees, which are generally barred from being collected in the landlord-tenant branch. Or a tenant can argue that the statute of limitations bars the landlord's ability to collect some or all of the rent that they are claiming. In particular, with regard to the late fees, if there is any kind of judgment against the tenant that can be redeemed, which we'll talk about later, no late fees can be considered as part of that redemption amount. Late fees can potentially, if there is a money judgment entered, be considered as part of that money judgment. More on the Late Fee Fairness Amendment Act, which is most recent legislation on late fees. Housing provider cannot charge more than 5% of rent as a late fee. The late fee in subsidized housing, so particularly relevant to the cases we see in the Right to Counsel Project, can only include the tenant portion. So that is to say that if a tenant's portion is $100, then the maximum late fee would be $5. There must be a grace period of at least 5 days, though if the lease specifies more, then the provisions in the lease hold. And housing providers may not charge tenants late fees that are attributable to non-payment or late payment by the subsidy provider. So if the housing authority has not processed a HAP payment timely, a landlord cannot assess a late fee to a tenant on that basis. Housing providers can also not charge more than one late fee per missed payment or apply future payments to late fees. That is to say that if a tenant is late, has failed to pay their January rent and the housing provider assesses a late fee on that, the housing provider cannot also assess a late fee on the February rent, which the tenant pays on time, simply by claiming that the tenant has paid the January rent and has not become current.
So in addition to defenses that we have to these cases, we also have the opportunity to file a counterclaim, a claim for a recoupment, or a claim for a set-off. And these are technical terms and can be kind of confusing. So if you have questions about when one is appropriate, please talk to your mentor. But I did make a chart that we'll start sending around with the Right to Counsel materials that I'm very proud of. So first, a recoupment is an equitable defense that seeks to offset the amount of unpaid rent. And so it can be used when there are violations of the housing code that are on the premises. It's limited to a total of the amount sought, so you won't get anything back, but you'll be discounting the amount that they're coming after your tenant for. And it's an equitable defense, so there's no statute of limitations. It can go back beyond 3 years. A counterclaim is sort of a more standard, we countersue either for money or for injunctive relief. Counterclaim for money applies to rent overpayments made to the landlord while the property was not in substantial compliance with the housing code. Unlike recoupment, it can exceed the amount sued for, so you can get cash back for your client, but it is subject to the 3-year statute of limitation for counterclaims. Counterclaims survive dismissal of the landlord's claims, which is great. The risk to counterclaims is if your client wasn't personally served, filing a counterclaim can open your client up for a money judgment against them. Set-off can be claimed for expenditures that were made by the tenant. They can be claimed as credits against the rent. So the classic example is tenant made repairs or bought supplies where the landlord failed to do so. It is subject to the 3-year statute of limitation for contract claims. Some non-repair expenditures may count, such as payment for utilities that were the landlord's responsibility, or for a hotel if they were constructively evicted. Note on all 3 claims, as I mentioned earlier, filing a counterclaim for money damages, tenant submits to court's jurisdiction or a money judgment against them, even if they weren't personally served. This rule does not apply to tenant only filing a recoupment, a set-off, or a counterclaim for injunctive relief or a counterclaim for repairs. A note on claim or issue preclusion that comes up in these cases. Landlords sometimes claim that the counterclaim cannot reach back further than the most recent judgment, including consent judgments, because of claim or issue preclusion. The Court of Appeals rejected this reasoning in Smith v. Greenway. Counterclaims in landlord-tenant branch are permissive. Prior failure to raise a permissive counterclaim is not res judicata, but claims as to specific months covered by prior judgments would be precluded. Following this decision, some landlords are seeking broad release of claim against unrepresented tenants, so you may run into this situation. An extra wrinkle is that these are all now sealed, and so we don't actually know what prior judgments are in existence, and so it's important to ask for this in discovery to the extent that the landlord has it, and if not, that's their bad.
Some other important concepts in landlord and tenant redemption, which we've alluded to previously. This is the principle that a tenant who has been sued for non-payment can redeem their tenancy, can pay off what is owed up until the date of the execution of the writ by the marshals. The signal case on this is called translux, so you will alternately hear this called translux as a noun or as a verb, i.e. the tenant redeeming or the tenant transluxing. The right to cure, a tenant who's been sued for lease violations other than non-payment has the ability to cure the violation within 30 days. With some limited exceptions. So for example, one strike cases, criminal activity, there's no right to cure. Tenants have the right to habitable unit. That is a unit that's safe, sanitary, and meets the requirements of the Housing Code and Property Maintenance Code. Tenants have protection from retaliation and discrimination. Tenants in DC have a right of first refusal to purchase their unit, either themselves or in conjunction with their neighbors under the Tenant Opportunity to Purchase Act, though this right has been rolled back a little bit for tenants in smaller buildings in 2018. And tenants have a right to vote on any condo or cooperative conversion. Moving on to the elements of the prima facie case for lease violation case that a landlord files against a tenant. So in order to make out this case, a landlord needs to prove first the existence of a landlord-tenant relationship, usually again through a lease. Second, the violation of some obligation of tenancy. An obligation of tenancy does mean a provision in a written lease or a violation of the housing code, and this violation must be substantial. The landlord needs to prove proper service of a legally sufficient notice to quit, notice to correct, notice to vacate, notice to cure, whatever you want to call it. The landlord then needs to prove a failure to cure and or vacate within 30 days. So what needs to go on the notice? So the notice to quit is a letter to a tenant alleging a valid reason for the landlord to regain possession, giving the tenant opportunity to cure it. So in order to give the tenant proper opportunity to cure, the notice must lay out in sufficient detail what a reasonable person under the circumstances would understand to be the manner in which they could cure the violations. It also needs to include a reference to the lease provision or the regulation that the tenant is allegedly violating. The description of how to cure itself must be specific. So again, going back to the reasonable person standard, the description not only of the violation, but of what must be done to cure needs to be laid out in specificity. The proper service and language on the notice itself is a condition precedent under Moody v. Winchester. That is to say that this is a 12b6 issue. So it is not a B4 or B5 issue with the process or the service of process. A notice being proper is a B6 issue. A 30-day notice requirement cannot be waived or modified by agreement or waiver in a lease or lease modification, and it is the landlord's burden to prove that they have properly served the tenant with this and to properly prove that the notice contains all of the required elements.
A landlord can't sue on the on these cases until the notice has expired or the cure period has ended, which is 30 or more days from the time that the notice was served on the tenant. For consistent late payment of rent cases, notice must expire on or after the first day of the rental period following expiration of the notice. So often more than 30 days. Because the way to cure those is by paying the next month's rent on time. The notice must allege violations occurring within the last 6 months before the notice is served. For most units, this does not apply in public housing. They can go back farther, or 3 years. If a tenant cures during the 30-day period but later violates again, a new notice must be served with a new cure period afforded. But any cure must be maintained for some period after the expiration. It's not clear exactly how long. But if you sort of cure on the 30th day and then violate again on the 34th day, that might not be long enough. So there are plenty of defenses in these cases. Number one, obviously, you deny the alleged violation that they're saying that you've committed. Number two, most frequent, I think, is that you cured the violation. They told me I had a dog that I wasn't allowed to have. We got rid of the dog within the 30 days. That the violation is de minimis or forfeiture is not warranted. I've seen this in cases where the landlord's saying, oh, the refrigerator was too full or the freezer was too full or something like that. But we can argue it in a lot of our cases. Waiver, affirming tenancy after the notice expires, accepting rent. Waiver of enforcement of a lease provision may be withdrawn by giving a clear notice to the tenant, like the 30-day notice to quit. Accepting rent alone doesn't seem to be enough for waiver, but there might be other things that would be. The landlord has acquiesced. I've had the dog for 3 years. The landlord walks the dog for me, etc. Or as we talked about earlier, retaliation. Some additional defenses include the landlord's violating the DC Human Rights Act, discriminating against me on the basis of a protected class, or fails to provide a reasonable accommodation for individuals with a disability. And then Federal Fair Housing Act, which is more narrow categories than the DC Human Rights Act. So usually we use both.
Some other defenses. There is Section 504 of the Rehabilitation Act of 1973. This applies to public housing, that is housing that is owned and operated by the housing authority, not site-based voucher, it does apply to site-based Section 8 property as well. It does not apply to privately owned subsidized housing. The ADA applies to public housing owned by the housing authority, and it does apply to how DCHA administers all of its programs. Other defenses. So in the Rental Housing Act itself, there is a substantive VAWA defense that is a defense that the violation is the result of an intrafamily offense. So for example, it is a complete defense if a landlord argues that a tenant has violated the lease through excessive noise and the presence of a weapon in the home. If the tenant can argue that the presence of the weapon, came because their romantic partner brought it into the home and victimized them. Reasonable accommodations. These are very broad remedies. This is asking for a change in a landlord's rule or policy. So they have a lot of utility, especially in the lease violation context, but they also have some utility in the non-payment context sometimes. So for example, a tenant who has problems hoarding can request a reasonable accommodation, asking for time to engage services on the basis that the hoarding, there's a nexus between that and the disability. A classic example is waiver of a no pet provision. And that includes the waiver of a pet fee for a tenant who needs a therapy or support animal. A tenant can request through reasonable accommodation a transfer to another apartment away from any kind of triggering, precipitating activities or events. A tenant can also get additional time to cure any lease violation, and this can even include additional time to cure a violation once the landlord has already filed. Some common issues that come up in terms of lease violations, particularly within subsidized properties, include an allegation that there are unauthorized occupants in the unit. So in a subsidized property, all household occupants must be approved and listed on the subsidy paperwork and the lease. Depending on the program, there are some limitations about the ability to add, especially adult family members. Generally, new adult family members are subject to screening as well. But as far as children or minors, or if there is a caretaking relationship or a spouse, those a tenant should be able to add. A live-in aid can also be added. It requires a separate approval process plus screening. And one thing to note is that, separately, a live-in aid has no succession right, which is something that, we see come up where if a family member will move in as a live-in aid and a household, a head of a household might die, and then the live-in aid has no succession right. So occupants of the unit are relevant for rent calculation. So any household income is included unless it's the household income of a live-in aid. Although if someone is a full-time student, then their income is excluded as well.
If an occupant moves in and is not reported and the landlord later finds out, that can be a problem. It can result in either a debt owed once the occupant's income is added, rent can be retroactively increased, but you would still have the right to cure a lease violation based on an unauthorized occupant by removing them once a 30-day notice is properly served. Each program has rules for removing a household member who has left. It's important for income calculation and if there's criminal activity in one of the tenant's household members. It can be challenging to do, and a lawyer can be really helpful for that process as well. Failure to recertify, we talked about briefly earlier, results in a notice to correct or vacate in public housing. It's treated as a lease violation. It can be cured. There is an administrative process available, but it's generally not practical. We see these cases often settling with a tenant being able to recertify. In site-based Section 8, it can result in a rent increase to market rent and or a notice to correct or vacate. Federal regulations allow a landlord to increase to market rent, which is a straightforward process that many landlords prefer. But it can also be treated as a lease violation subject to cure. Often when we place these cases with pro bono counsel, it will require them to recertify, figure out what to do with the retro debit. There is no administrative process to challenge in Section 8, but you can request a 10-day meeting with the rental office. program, it results in DCHA doing a recommendation for termination to the voucher holder. This is outside of the court process. Of course, DCHA has their own administrative process, and the voucher holder can challenge termination. Through that, DCHA may stop payments to the landlord, resulting in both a non-payment case and a voucher termination issue. Because these would no longer be subsidized at that point, it's unlikely that those cases will come through the Right to Counsel Project, but never say never. Um,
Other common recertification issues that you might see are the housing authority or the landlord imposing retroactive change to seek missing funds. They are permitted in some cases to claw back some funds for instance, unreported income. So, be careful to look at the applicable regulations and, see what they are and are not permitted to do. There can be a statute of limitations issue if the housing authority or the landlord sits on the debt for more than 3 years. If there's a failure to report a loss of income or lower income, that can be a problem for a tenant as well. Generally speaking, the reduction in a tenant's portion of the rent only goes into effect when it is reported. So it's really important that a tenant reports any change in their household or any loss in income. If they don't do that before the first of the next month, then the housing provider or the housing authority cannot go back and give the tenant a kind of rebate for what they overpaid. And then other common issues that we see are difficulty verifying income. The easiest way to verify income is through a traditional kind of W-2 employer. They can use the enterprise income verification, EIV, to verify the income. But sometimes it's difficult for tenants with kind of spottier income. There are regulations and guidance on alternate verification procedures. Generally what they kind of default to is getting a sworn notarized statement by the tenant, as a matter of last resort. Finally, tenants with kind of sporadic income or seasonal income can experience some issues. If somebody, for example, is employed part of the year by DCPS, and they have zero income during the summer, and then they have income during the school year. There are ways of, in the regulations, of reporting that and of calculating that, we can kind of lean on or use as a way of making a tenant's recertification more predictable, rather than requiring them to perfectly do complete interim recertifications every time that sporadic or seasonal employment starts or stops.
Hi, I'm Molly Katchen. I'm a supervising attorney at Legal Aid DC, and I'm going to talk through some technical defenses that can be raised in these cases. And these are typically defenses that are asserted at the first court date or the first time you appear with your client in a motion to dismiss, so prior to an answer being filed. The first thing that's important to look at is there are licensing and registration requirements for landlords in DC. Some of these are relatively new in the last few years with all of the legislative changes. But all owners must have a current basic business license before filing a case in court, an eviction case. All owners also must be registered as covered or exempt by the rent stabilization program and provide a registration number or exemption number. And this is paperwork that needs to be in the complaint packet that's filed with the court. So it's a good, the complaint packets these days have gotten very large. And so it's important to go through all of the paperwork at the outset to make sure all of the required documentation is in there. One thing that's important to look at on these documents is the names of the entities, and the name of the plaintiff needs to match the name on the basic business license. And on the RAD registration, oftentimes the paperwork hasn't been updated and landlords are filing old registration documents, and that can be a basis for the case to be dismissed. So that's something to look at. So all pleadings in landlord-tenant court have to meet the Iqbal Twombly standard. So they have to set specific facts to state a plausible claim for relief. So that's just something to look at on the complaint paperwork itself. Some examples of insufficient pleading standards on the complaint is insufficient pleading of a failure to cure on the complaint in a notice to quit case, or failure to plead the elements of a drug haven case, specifically that the violation is ongoing. And I don't know that we are placing any drug haven cases through right to counsel, but it's possible. But in that instance, it's a very serious allegation, and the landlord has to prove that the unit is currently being used as a drug haven and it's an ongoing violation. So that would be something that would need to be pled on the complaint to meet this standard. So I think, as Adam previously said, all cases now in DC are required some sort of pre-filing notice. And so failure to provide that notice is a basis of dismissal. In a non-payment of rent case, the notice has to be served at least 30 days prior to the case being filed and has to contain the following language or substantially similar language. And so it's important to look closely at that notice to make sure that it contains language that's very similar to this, and it's spelled out in the statute what the language is. In a notice to quit case, the notice itself must be sufficiently specific. So it has to state the alleged lease violation in specific terms. It has to state a specific cure provision. It has to state a minimum time to vacate, and it has to include the rent control registration or exemption number. It also must be, the notices also must be included in English and Spanish. Sorry, this is like an awkward looking at the screen and my notes here. So the notices have to be served both in notice to quit and non-payment of rent cases. The notices have to be served. They have to be served by personal service, substituted service, or posting. If the service is by posting, the landlord has to provide the court with a date stamped photograph of the posting on the tenant's door. It also is supposed to be mailed following that. The process is they serve the tenant first, and then for notice to quit cases, it has to be served on the rent administrator. And so within 5 days. So that's something to look at in notice to quit cases, whether or not there's a stamp indicating that that notice was served on the rent administrator. So dismissal is required for some of these technical defenses, specifically if the landlord fails to provide the required pre-court notice, if the landlord files the eviction case before the time limits have elapsed in either type of case, if the landlord doesn't provide a photograph with a date stamp for service by posting, when the landlord knows the tenant speaks another language other than English or Spanish, which is a language covered by under the Language Access Act. Additionally, in a notice to quit cases, the notice must include language that victims of intrafamily offenses have additional defenses in these cases. And so that's a specific paragraph that has to be in all notice to quit cases. And if it's not there, the case must be dismissed. Additionally, in federally subsidized properties, the landlord must include notice, a VAWA notice, which is the notice of rights under the Violence Against Women's Act. And so that needs to be in the paperwork as well. And if that's not there, that's also a basis for the case to be dismissed. defective service of process. So the complaint itself has to be served properly as well. So we were previously just talking about all of sort of the pre-filing notices, but the complaint itself also needs to be served. The service has to occur at least 30 days before the initial hearing, excluding Sundays and legal holidays. So it's always good to count out the days and remember if there's been a legal holiday in there, because there's oftentimes, if it's very close, we've seen process servers mess it up where they're actually like a day too short because they didn't count some sort of federal holiday. Personal service is preferred, and diligent efforts at personal service are required prior to some other kind of service by posting and mailing. Posting and mailing is only appropriate after the process server makes 2 attempts at diligent efforts, which is 2 days at 2 different times of the day at personal service. And then if they post it, again, they are required to take a photograph of it on the tenant's door, and that needs to be included with the affidavit of service. The process server has to complete a declaration form that has to be filed at least 21 days prior to the initial hearing, or the case may be summarily dismissed by the clerk. These affidavits of service declarations of service are entitled to the presumption of accuracy, but that does not mean they're accurate. And so if your client says, I never got it, or I wasn't served, you should certainly challenge it, because, they're not always accurate despite what, the paperwork says. And so it's important to talk specifically to your client about that, and, put forth any challenges they have. So for a lot of these technical defenses, the court may dismiss the case sua sponte, but they may not. And so basically, when you show up for your initial hearing, if the pleadings have a lot of issues in it that have been identified by the court will say, we have a number of notes on the case, and oftentimes ask the landlord, if they want to address those notes. But you shouldn't rely on that. You shouldn't rely on the court, catching all of those. And so it's always good to file a motion to dismiss prior to the hearing, to make sure all of the issues are raised. You can make a motion to dismiss orally at the initial hearing, although it's preferable to file one in advance if you're able to. But that just may depend on the timing of when your initial hearing is and when you get the case. The court may also allow the landlord time to cure some of these violations. You should certainly try to push back. You may not always be successful. They may allow the landlord to cure some of these violations, particularly if the landlord says, oh, I attached an outdated basic business license by accident, but I actually have the correct one. They often allow them to cure it, but it's certainly worth pushing back and, reminding the court that these, the approach to these cases is hyper technical, and the landlord needs to comply with all of the requirements under the law. I think that is it for technical defenses, unless there's any questions. We're doing questions at the end.
Do questions whenever anyone has questions.
All right.
Any questions?
All right, Sunny, you're up.
Would we know if there were questions online? We would see those? Okay, thank you.
Okay, I'm gonna test this out quickly. Okay, good. Please feel free to interrupt me if you have any questions, if you're online, if you're in person. This is sort of in-depth Civ Pro, which was never my favorite topic, and here I am doing it for a living. So I understand if you all are in the same position. My name is Sunny Desai. I'm a managing attorney at Legal Counsel for the Elderly. We represent seniors. My team specifically helps seniors who are facing eviction issues. So you've learned a lot about what the case is about, what defenses you might be able to raise, etc. Where does the rubber meet the road? That's this part right here. So this in a nutshell is the court process. There are other parts to it that aren't on here, but this is generally speaking, from beginning to end, what a non-payment of rent, lease violation, eviction case would look like. The parts that are in solid outline are essentially mandatory. Those will happen if a case goes all the way through to the end. The parts that are dotted are optional, so to speak. May happen, may not happen, depends on how the case progresses. So first thing I will say is in DC Superior Court, there are magistrate judges and there are associate judges. Landlord-Tenant Court is manned by magistrate judges. So, thank you. They are staffed by, thank you, magistrate judges. Magistrate judges we'll typically ask if you consent to them hearing the case when the case first gets started. Generally speaking, we do consent to magistrate judges, but there are times when you may not want to consent to a magistrate judge. All initial hearings are staffed by magistrate judges. Every case starts with an initial hearing, and then it can go in many different ways. And we'll talk more about that. The whole process from beginning to end takes anywhere from 3 to 12 months, let's say. That's generally the timeline you're looking at. Jury trials take longer, bench trials take not as long. And one thing that's not on here, which I'll cover later, just pin it for later, are ERAPS days, which throws a wrench in the whole process. In a good way, most of the time. This process is a summary process, though that does not mean it's an expedited process. Again, we'll talk more about that later. Essentially, it's not a full-on trial, full discovery, etc. process, generally speaking. One other thing I'll say about initial hearings before moving on is many of our clients think that this is their chance to talk to the judge, tell their side of the story, etc., etc. It is not. An initial hearing, best way I can describe it is just so the judge can figure out what we're doing in this case. They are not ready to hear any evidence at an initial hearing. Okay, so an application to proceed in forma pauperis, IFP, is also a fee waiver, essentially. All of our clients generally qualify for a fee waiver. We just have to fill out a form. The clerk can generally approve it. It waives all kinds of fees, like a $75 jury demand fee. It can be submitted in advance. We generally try to, but sometimes you have to go to your first hearing and say, we have a pending IFP, if the judge could approve it. Most of our clients, many of our clients, are on some government income-based program like food stamps, Medicaid, etc. Those are supposed to be essentially automatically eligible for fee waivers. As I mentioned before, this is a summary process. There's not a lot of discovery, but one bit of discovery that's sort of built into the rules, Landlord-Tenant Rule 10, landlords are required to attach ledgers to their complaints, essentially. They're supposed to provide ledgers with a filing, or at some point down the line if they fail to file it with the complaint. And if they fail to do so, there are sanctions. That could mean a continuance, that could mean a declining protective order. It could potentially lead to a dismissal as well, but we don't see that very often. The counsel generally, if not attached, the opposing side, the plaintiff, generally has 3 days before the next hearing to produce the ledger. Most of the landlord, there's a handful of landlord attorneys that generally practice in landlord-tenant court. They're very used to the process. This process, everything I'm going to cover is generally secondhand knowledge to them with an asterisk. You may find that most of the cases you all see have a ledger already attached. But the thing to look for is make sure that the ledger goes back to the last time the balance was at 0. That's what the rule requires. That isn't often found. Sometimes you'll see ledgers where the balance, the first line is transferred balance $10,000. It's like, okay, where did this come from? And ledger just doesn't explain it. Responsive pleadings. So if you want to ask for a jury trial, you have to file a written answer and jury demand. That's Landlord-Tenant Rule 6. The request must happen at the initial hearing stage. It can be at the further initial hearing stage. If there's a further initial hearing, hopefully all rights have been reserved. More on that is at Rule 11. Landlord-Tenant Rule 11b2 talks more about that. Used to be, we had to make sure we said the words all right reserved at every initial hearing. The rule changed. Sometimes it's automatically reserved, but not always. So check that rule, depending on what stage of the process you're in. You can also file counterclaims, recoupment, set-offs, which was talked about earlier. And you can also amend answers within 21 days of filing. Most of the time, we encounter this when a case comes to us when it's already progressed a little bit. Maybe the tenant has talked to somebody, filed their own answer, and that might need amending. May not ask for everything that needs to be asked for. There are, again, as I mentioned, it's a summary process. There are only a limited number of claims that you can assert in a counterclaim. You cannot start asking for personal injury damages, for example, in landlord-tenant court. If you're asking for a bench trial, written answers are not required, though you may want to file one anyways, especially if you're alleging housing code violations. The biggest reason to do that is you're putting the landlord on notice. So down the line, the landlord can't say, well, no one ever told me what exactly the housing code violations are. How am I supposed to fix it? Well, at least in the answer, you were told exactly what the housing code violations were. More responsive pleadings, motion to dismiss. This is probably the most common written motion that we file. It must be filed before the answer, generally speaking, and consult Civil Branch Rule 12 for the timing of that. Just a quick note, there are landlord-tenant branch rules and civil branch rules. All landlord-tenant branch rules apply in landlord-tenant court, obviously, but only some civil branch rules apply. And Rule 2 of the landlord-tenant court rules talk about which civil rules apply. So Civil Rule 12 is one of those that does apply. So motions to dismiss can be based on a wide range of issues: improper service of complaint, failure to properly serve legally sufficient notice to quit, which was already talked about by Adam, insufficient facts alleged in the complaint. So that's failure to state a claim. That's a 12b6 motion that he was talking about. A case could also be dismissed for some of the technical defenses that were talked about earlier: failure to attach or failure to have a basic business license, failure to attach a RAD form, or the RAD form is improperly filled out. Sometimes those motions can be raised orally at the initial hearing without having filed something prior. I wouldn't recommend it because every magistrate judge is a little bit different, and if the issue is complex enough, the judge will probably make you write a motion anyways. But it happens all the time with pro se landlords. They just file a complaint and nothing else. And honestly, probably not worth your time to write a written motion to dismiss. Most likely the judge will dismiss that case sua sponte at the initial hearing, but you could probably raise those arguments orally and get the case dismissed, most likely. Worst case, the judge tells you to write a motion later, so no harm, no foul. So those are motions to dismiss generally, but some issues are more appropriate for summary judgment. They're best raised after discovery. So if the landlord is alleging that we put you on notice for a lease violation and we gave you 30 days to cure it, let's say it's an unauthorized occupant. 30 days went by and now we're saying that unauthorized occupant is still living in your apartment. They file a case, we go to discovery. Turns out they don't really have any further evidence that tenant failed to cure. That could be a motion for summary judgment. And obviously we would know that until discovery happened. Okay, let's talk a bit about protective orders. So this is covered by Rule 12I. This is a court order that requires a tenant to pay rent going forward into the court registry instead of paying it to the landlord. So if we're at an initial hearing today, July rent, for example, could be that the tenant has to pay that into the court registry instead of when it comes due and paying it to the landlord. This does not include any prior rent. So the case is really about rent arrears and rent that has not been paid. Protective order is about rent that will come due while the case is still pending. Protective order can date back to the date of the initial hearing. However, the landlord has to reserve rights. And the purpose of this really is to protect the status quo. If the tenant is alleging that my rent is too high because of the housing conditions, the rent should be lower, then the protective order can be adjusted so that it matches the condition of the unit. It also protects the landlord because it ensures that the tenant will continue paying rent while the case is being adjudicated. And sometimes it's helpful for settlement because there's a large pile of money sitting in the court registry that when you get to mediation, that can be used as a tool to settle the case. Hey, we will release all of the protective order to the landlord if the landlord makes the following repairs by a certain date. There can be sanctions for failure to make protective order payments, and this is sometimes weaponized by the landlords. Essentially, if the orders are generally by the 5th of the month, the tenant is to make a certain amount of rent payment into the court registry. If that doesn't happen, the landlords can file for sanctions, and at a hearing, essentially argue that because this payment was not made, the tenant's defenses, perhaps their jury demand should be, perhaps the counterclaim should be stricken, and that trial date should be expedited, or sometimes even asking for judgment. If the tenant catches up on missed protective order payments by the hearing for the motion for sanctions, usually the judge understands and does not grant the sanctions. However, if the tenant is a repeat offender, then it gets more likely that sanctions will be granted. Again, Landlord-Tenant Rule 12I talks more about all the different mechanisms of the protective order. I won't read all of this, but one thing to note is a protective order is generally requested by the landlord, but can be requested by either party. Why would a tenant want to request a protective order? Housing conditions is a big one. If there's a rodent infestation that they were treating, but then stopped treating, you may, in the middle of a case, request a protective order, either a change in a protective order or a protective order that was never entered to be entered so that the tenant doesn't have to pay the full amount of rent, something less than the full amount of rent because of the substandard housing conditions. There's usually a hearing required when a protective order is requested, but in practice, it often proceeds by proffer. It's a very busy court docket, as you might imagine. There's not often times to do these mini trials for what the rent should be. So often it just proceeds by proffer. And generally only applies in non-payment of rent cases. In lease violation cases, there usually should not be a protective order entered. So as I described these mini trials that I talked about, those are called Bell hearings, and that it's called a Bell hearing after the case Bell v. Sindloas Realty. I would never have been able to pronounce that right. Doesn't really matter. But a Bell hearing is essentially each side either producing proof as to why rent should be what it is. Obviously, the landlord's going to want 100% of the rent in most cases, and we would argue for something less than that. You should be prepared to present photos, at least client testimony, maybe some inspection reports. However, as I mentioned earlier, oftentimes proffering that evidence is sufficient. Many times, actually, most of these hearings are in person. Many times we just go in the hallway and work something out with the opposing counsel because, as you may find, landlord attorneys often don't want to do evidentiary hearings or trials. So it's a big point of leverage for us oftentimes. I've mostly talked about housing conditions with protective orders. However, sometimes a protective order is needed in subsidized housing cases. I have a case right now where when clients started renting the place, her rent was something like $150, $200. And all of a sudden it went up to $2,000+. Obviously a big difference. And we suspect that something's up with her voucher. The voucher payment stopped for some reason. And we ask for a protective order hearing so that we can set the protective order payments at the lower amount, obviously not the higher amount, which client cannot afford. So, as we mentioned before, you could ask for a bench trial or a jury trial. Which is better and why? It just depends on the circumstances of the case. Jury trials take longer to from start to beginning, and that delay can be beneficial to our clients. Of course, if you ask for a jury trial, that's more protective order payments a client has to make, many more months of protective order payments, and that could be a liability in a case. However, jury trials are much more expensive for landlords to litigate, so they want to avoid them as much as possible. Jury trials also allow for some discovery, not full discovery, not depositions, etc., but some level of interrogatories and requests for production of documents. And then mediation is now a requirement in bench trials and jury trials, so no difference there. With a bench trial, it's a shorter process, a quicker outcome. If a tenant can pay protective orders, no problem. Maybe a jury trial would be great. However, if there are some issues, if you were like, I don't know, maybe a couple of months would be fine. If it goes on longer, the client may not be able to make protective order payments, then a bench trial might be a better option. Also, some clients are just tired of dealing with their landlords. They just want this process over with. They don't want to come back to court multiple times. Discovery is sometimes available in bench trials, but you have to request it, and usually it's limited. I think the typical practice is 5 interrogatories, 5 requests for production of documents. But again, you have to request it. I generally try to have a reason as to why I'm asking for it. So the case I mentioned earlier about the client whose rent spiked up to $2,000, we asked for discovery. It was already set for a bench trial when I entered the case, so we ended up asking for discovery in that bench trial case. So the jury trial track, when you ask for a jury trial, one of the first things that happens is the court starts scheduling how the case is to move forward. They pick 2 dates. One is the close of discovery, and one is mediation. The jury trial date isn't set yet. The typical practice is to close discovery 60 days after the jury demand is filed, but you probably want to ask for an extension, at least 15 days. Mediation is typically scheduled several months out after the close of discovery, so that mediation can be more productive. And if mediation doesn't resolve the case, then the judge will schedule the next hearing and set it on the track towards trial. The case is also certified to an associate judge and moved to the civil actions branch. That doesn't mean that all court proceedings will happen in the civil actions branch. Some motions are still heard in landlord-tenant court, and that's Rule 13I. Again, just because the case is moved to civil actions branch doesn't mean it's still not a summary process. All of that is still maintained, limited discovery, limited schedule, etc. And as mentioned before, discovery is a matter of right in jury trials. That's typically 10 interrogatories, 10 requests for production documents. You want to sort of have these ready to go right after you ask for a jury demand. Discovery responses are due 30 days after service, and extensions are not readily granted. And there's specific rules saying that you cannot serve discovery within 30 days of closing. So all this is a reason to ask for that extension and also get these discovery requests out as soon as possible. So when you get to mediation after discovery, the mediation occurs through the court's multi-door dispute resolution center. The mediators are all work for them. The process is handled by them, not by the superior court staff. 30 days before the mediation, you have to file a confidential settlement statement, essentially describing your side of the story. Other party does the same. Helps you sort of, again, have a more productive mediation, hopefully. And you want to be ready to essentially make your argument. This is obviously a confidential process. There could be times where you don't want to disclose everything. I certainly have had mediations with a lot of landlords that are very cagey. They just want the client to move out, for example, not interested in discussing anything else. However, I think for our clients, it's better to come prepared with documents, photos, other evidence as to why the landlord should settle. I have an interesting mediation coming up in a jury trial case. We'll see how it goes. It's landlord filed a non-payment of rent case over 1 month's missed rent, which client caught up on. So landlord was ready to dismiss the case, but my client pro se filed a counterclaim and a jury demand. So the case is not over yet. So the mediation is just going to be over the counterclaim. And she wants 70% rent abatement. So we'll see how that goes. That's our starting offer. So I know my client's position. Obviously, I've counseled her that may not be the best position, but those are the kinds of things you want to be prepared for in mediation. I can't make her say another offer, but I'm sure I've counseled her that we may have to come down from that. So. If the mediation fails, as it might in mine, then the court will schedule a pretrial conference. Yes. Civil Branch Rule 16 goes into more detail about the pretrial conference. 5 weeks before the pretrial conference, you have to meet and confer with the landlord. That's a 16C conference, refers to the rule, to provide exhibits, discuss stipulations, narrow the issues. 4 weeks before the pretrial conference, all pretrial motions are due. And then 1 week before is when the joint pretrial statement is due that you and opposing counsel will work on. At the pretrial conference, be prepared to discuss the statement, any outstanding motions, trial logistics, etc. The judge will just want to know what the status of the parties is. I think really the judges are interested to see if they can force a mediation at that point. Essentially, no one wants to go to trial, but that may not be possible. So the scheduling of the jury trial will then happen at the pretrial conference. Sometimes the pretrial conferences are continued, but again, this is supposed to be a summary process. So there is a resistance to sort of indefinitely continuing conferences, mediations, etc. You may want to ask the judge to schedule a final pretrial status hearing a week or 2 before trial if there are any outstanding issues. It could also be a good time to exchange exhibits for the last time, or address any motions that are pending. So that's the jury trial track. The bench trial track is quite a bit different. The case is not certified to the civil actions branch. It remains with the landlord and tenant branch. Everything stays in the landlord and tenant branch. There's typically no schedule. There's no discovery as a matter of right, though, as I mentioned, you could request some limited discovery. There's no specific judge assigned, whereas in the civil actions branch, they will tell you exactly what judge is assigned to your case. And you will get mediation and a trial date pretty much right away. And it's not unusual for those trials to be moved around quite a bit. You'll go to the court you were assigned to, and the magistrate judge might say, okay, I can't hear the case, but the judge in courtroom, whatever, is ready to hear your case. There might be some very last minute things. I had a client who just neglected to tell all of us that it is a very important heart procedure in an hour. So the judge was like, okay, well, come back tomorrow. So you have to be ready for some of that uncertainty. You have to build in some of that uncertainty. Okay, motions practice. Motions to dismiss, we already sort of covered earlier. These are some other motions that might be common. Motion to compel discovery. This is typically filed when opposing counsel either does not respond to your request or the responses are inadequate. Again, I had a case recently where I received in the mail just a bunch of documents, and I was like, I guess this is response to discovery. No responses to my interrogatories. So I was just about ready to file it. I sent an email first saying, hey, I didn't get adequate response. Luckily for me, somebody just forgot to hit send or forgot to put all the documents in the mail. So they emailed them to me and it was adequate. So we did not end up filing a motion to compel discovery. With discovery disputes generally, I'm as sure you all know, judges hate resolving discovery disputes. So as much as you can, try to resolve it informally with opposing counsel, though that's not always possible. Another common motion, motion for, wow, I'm forgetting what a TRO stands for. Thank you. Motion for a temporary restraining order or a preliminary injunction. Usually we file these for immediate repairs. So we've had cases where landlord files for non-payment rent or something like that. We file, answer a jury demand, maybe a counter complaint, and probably as retaliation, they cut off their electricity. And in those kinds of cases, that electricity needs to be turned back on. My client can't do it on their own. So we have to file a TRO, preliminary injunction, asking the judge to order the landlord to turn it back on. Motion for joinder. Typically, we've done these when we want to join DC Housing Authority. If it's a case where landlord is alleging that while the tenant may have paid their portion of the rent, DC Housing Authority has not paid their portion of the rent. That obviously is an issue between the landlord and DC Housing Authority, but since they sued our tenant, we also want to add DC Housing Authority to the party. Let's all have fun together. If you are in this position where you have to join DC Housing Authority, definitely consult your mentor. There are some challenges. I'll just leave it at that. You would not think there would be, but there are in joining DCHA specifically. Okay, and then lastly, all of these motions, responsive pleadings that I mentioned, all of them need to be filed through the court's e-filing system, which is called Odyssey. So you want to make sure that when you get a case, even if you're filing a limited appearance, that will have to be done through the e-filing system called Odyssey. You want to make sure that your firm has that account set up. They probably do. But you also want to make sure that you are registered through that system, and you can't do that on your own. You need your administrator at your firm to send you a link, etc. So just make sure you're on top of this. You could probably do this today if you wanted to. There are some processing delays, so don't expect it to happen same day. And again, this is a brand new system, 2 years old, but brand new, relatively speaking. So there are still some growing pains and issues with filings that aren't resolved immediately. So just build in some time, especially if it's your first time using the system. Okay. Any questions? All right. I don't see any online. Thank you.
All right. So as I said before, I'm Molly Katchen. I'm with Legal Aid. I'm going to talk now about working up a landlord and tenant case. So kind of like the process, our suggestion for the process for what you should do when you first get a case. So obviously the first step in the process is to meet with your client and sign a retainer agreement. You know, ideally you would have that meeting in person if possible. You should read the retainer to the client orally and give them a copy to read and sign, but don't just give them a copy to read and sign because you want to make sure they fully understand it and have an opportunity to ask any questions. You should start by going through the interview checklist that we have in the Getting Started guide. Talk to your client sort of about their history, what's going on at the property. There's a whole list of questions in there that kind of help lead you through like an initial client interview, but basically you're trying to get a sense of like what's going on and what your client's goals are. It's also useful in that first meeting to have the client sign any release forms that you anticipate needing. If you don't end up needing them, it's helpful to have them signed, because if they pop up later, you don't have to then contact the client to meet with them to get the information signed for you to move forward. It's important to talk to your client about a plan for keeping in touch. And I can't stress this enough, that it is very, very important that you speak to your client about the need to remain in contact with you. And also, if possible, talk to them about other folks that you can reach out to if you can't get in touch with them, like if their phone gets turned off or something like that. Obviously get consent to talk to them, but I always like to ask, like, if I can't reach you, is there someone I can call who can get a message to you? Are you okay with me, talking to this person briefly and asking to relay a message? Just because it is not uncommon for our clients' phones to get shut off or people to go in and out of touch. And so it's really helpful to have previously identified an alternative point of contact. You should talk to your client about sort of the court process in terms of some hearings being virtual and some being in person. Talk to them about their ability to join video calls and virtual hearings by video if they have that as an option. It's not necessarily required in sort of the initial hearings, and typically hearings where there's testimony, ideally folks would be in person, but if someone is going to be testifying virtually, the court really prefers folks to have video on. So I would talk to them about a plan about that if they can't be in person for some reason. You want to talk through the general schedule of a case moving forward, what will happen when, what court dates will the client have to attend, and generally sort of your expectations for the case. So take a look at all of the court paperwork, go through the notice of past due rent, the complaint, the notice to quit, all of the things we sort of previously discussed in the technical defenses sections initially. Make sure all of those details are included, where the notice is provided in English and Spanish. Is there a lease provision cited? Is it correctly cited or quoted? You may or may not have a copy of the client's lease at the time, but if you do, you can compare it to that. If not, a lease is something you generally get in discovery. But basically just go through all the paperwork, make sure all the technical requirements are met. Look at the service, talk to your client about service, look at the declaration of service if the person was personally served, and see if there's any sort of things that stand out, that jump out to you in the description. If you think that it's inaccurate for some reason, if your client is contesting service, look for the photograph, make sure that you can clearly see the door in the photograph and that the numbers match up. If your client is disputing service, but there's a photograph, sometimes you can ask, is there any identifying things on your door? Do you have something posted that is not showing up in this picture? I had a case one time where a client was, had like a sticker of like a prayer on her door, and that had been there since she moved in, and that was not in the photograph. And so she was able to bring a photograph of her door, and we were able to dispute service that way, saying that posting was not actually a photograph of her door. So, talk to your client about all that stuff. Look at the different dates and times of attempted service if they're serviced by posting, to make sure that it complies with the statute. Look through the paragraphs of the complaint. Make sure everything, that needs to be in there is in there. Talk to your clients about their goals and defenses. You want to talk to them about them at the initial meeting, and really like every subsequent meeting, if you can, sort of, you want to make sure that your client's goals haven't shifted during the course of the representation. Things haven't happened in their life that make them want to go and, make a different choice. So you want to continue to have sort of that open conversation with your client throughout. Talk to your clients about dismissal if it's possible. There may be instances where could be a basis for dismissal, but your client doesn't want the case dismissed for one reason or another. That could include a lot of the dismissals we talked about previously, right, are all dismissals without prejudice. So the case is just going to get refiled. So maybe your client doesn't want to do that, just wants to move forward now because there are significant housing code violations they want to get repaired. And so they want to focus on that. And so there may be reasons why a client doesn't want to get a case dismissed. So you want to talk to them about all those options. You want to get a list of all the repairs that are needed and think through any of those are whether any of those are emergent needs, whether or not there's a basis for a TRO or a PI because there's something that needs to be repaired right away. Talk to your client about what documents you might want, so they can start gathering documents. Make sure that, if they have any photographs, that you're getting copies of those. Talk to them about settlement generally, the process, the timing, the options. Talk to your client about whether or not their ultimate goals in the case are to stay in the unit or to move, keeping in mind whether or not the client has a subsidized unit. Sorry, I thought you were raising your hand.
Sure.
And I can't stress this enough, but if your client is in a subsidized unit that is attached to the unit and not a voucher, you should certainly talk to your mentor before a client signed any kind of move out agreement, because that would result in them losing that subsidy. If it is a voucher, it's a different situation, but any other type of subsidy, public housing, if a client has indicated they want to move, please talk to your mentor before a client signed any kind of move out agreement in that situation. You can involve caseworkers, family members, third parties when useful and appropriate, obviously making sure that you're, talking about how that affects attorney-client privilege and confidentiality. But a lot of times folks in your client's life can be really useful in gathering information and talking through kind of situations. Talk to your client about the different options, your theories, defenses, any sort of problematic proof problems they have, any credibility issues you're concerned about. Talk to your client. Clients sometimes don't always have a realistic expectation of how a case is going to go or what they can get out of it. I think the example Sunny gave is a pretty good one in terms of an abatement. So, obviously your client, we can ask for what the client wants, but it's helpful to sort of have previewed for them what you think is going to happen in those situations so they're not caught off guard. Talk to them about their ability to pay a protective order and how that would impact the case. Bench trial versus jury trial, the different benefits and concerns that may arise in those situations to decide which route your client wants to go. Counterclaims, recoupment, set off, all of the things that are previously discussed, and determine whether or not that may be applicable in the case or useful. Go to your client's unit, preferably with someone else who can take photographs, a legal assistant or an investigator who could potentially testify if necessary, take photographs and video, collect any relevant documents from your client. It's often easier to get documents from your client when they're at their unit and they can just look through their paperwork, or they could hand you a stack of paperwork and you can look through and figure out what is useful and what is not useful. I one time had a client drop off an entire cardboard box worth of basically every paper she ever had, because she wasn't sure what she had. And then I, spent time going through it. I could have done that at her house. She wanted to bring it to me, but sometimes they don't know what they have. For tenants who are in the voucher program, it could be useful to request a tenant file from DCHA. In order to do that, you have to get the client to sign a release form. So if you have a voucher tenant, a DCHA release form is something useful to bring that initial meeting and just have them sign it. You don't have to use it, as I said, but that way you have it if you need it. Think through whether or not there's any records you want to subpoena, any witnesses you want to talk to, whether or not it's appropriate to request a DOB inspection or DCHA inspection. Check the court records for prior cases involving the same parties. That is difficult because cases are now sealed. It's helpful. It's always good to look and see. Sometimes if a case was not settled or not dismissed and there was a judgment entered against your client, probably they're not still in the same unit, I would suspect, unless for some reason the landlord didn't follow through with that. But it's always helpful to check. But you may not, just because it's not there doesn't mean it didn't happen. And so talk to your client about that. So I think, as already discussed, sort of the first substantive hearing you'll encounter, generally, unless there's some sort of motion to dismiss hearing, is a bell hearing. So you want to talk to your client about how much they can pay, how bad the conditions are, what kind of abatement you're asking for. If you're asking for an abatement, prepare all of your evidence, documents, talk to your client, prepare them to testify. It's, these bail hearings typically are settled, and so it's always helpful to reach out to opposing counsel ahead of time. You may or may not be able to reach them before the hearing, but it's always helpful to try. A lot of times these settle like, right as the hearing is starting. But sort of think through any evidence or anything you might need for that hearing. So when you get closer to mediation, it's a good time to check in with your mentor and kind of see where the case is. This is, it's not necessarily the first opportunity to talk to the opposing party about settlement. If you've been in, you can talk to them about settlement at any point, but they're oftentimes may not be engaged in that process until you get closer to mediation. So you want to make sure you meet with your client in advance of the mediation, talk through their goals, talk through what's realistic in terms of a settlement agreement, explain to them how the mediation session will go. Mediations, I think the default is still that they're scheduled virtually, but the parties can request that they be scheduled in person. So think through whether or not, your client may want to be in person or whether or not it will be easier. It is, a lot of times it is easier for people to sort of negotiate when they're all in the same room together versus Zoom, but there may be reasons why your client doesn't want to be in the same room with the property manager, or, for work-related reasons why they can't be there. So it's not crucial, but it's just something to think about. And that gets, when the mediation gets set at the, is when you have to ask for it to be virtual or in person. At the mediation, you want to be, the way these mediations typically work is that mediator will turn to the plaintiff and say, okay, why are we here? They'll give a little spiel about what they think is going on, and then they'll turn to you. And so you want to be prepared to sort of detail your claims and defenses, and specifically the housing code violations and, what we're asking for. And then they will oftentimes send the parties to breakout rooms to discuss, but the parties can also discuss in a room together. It's helpful to have a draft agreement going into mediation, especially if you think it's likely to settle. You don't necessarily have to sign that agreement in during the mediation, but if all the parties are there, it's sometimes often a good way to get things resolved without a lot of like follow-up afterwards. So because everyone's there and focused on it. So if you think you might settle, it's always helpful to have a draft agreement ready to go. You can like write it out by hand. That's like what people used to do. But these days now everyone has their computer there, so it usually gets typed out, but it is, it's helpful to have that going in. Otherwise you just sit there and like hand write a long agreement in mediation.
Especially it can be helpful to draft in advance so you can send it to your mentor and get feedback on it, talk to them in advance. If you think you might settle in mediation.
Preparing for trial. So, you want to think through all of the elements that the landlord has to prove. What kind of case is this? What are they required to prove? What evidence are they going to need to prove that? Is there any way to get that evidence excluded? What does the landlord have to do to get that evidence in? Develop a theme for your case. Incorporate good evidence, but don't just, ignore bad evidence. Have an answer for that because it's going to come up. Think about who you may want to call as a witness, talk to your client, interview potential witnesses. You can consider asking whether to get a signed witness statement. Consider whether or not you want to subpoena any witnesses. Think about potential exhibits, review your discovery, consider whether there's any other inspections, consider whether you need an updated inspection, whether or not you'll need any documents from third parties like DCHA or DOB. You can subpoena both the documents and someone to authenticate them. You can also request a business records declaration, but keep the witness on call. Sometimes the landlords will just, they'll consent to the report being entered, but not always. So you want to be prepared in case you need someone to authenticate it. Prepare all of your, all of your trial elements ahead of time, opening, closing, witness directs, any possible crosses you might have, label all your exhibits, and prepare an exhibit list for the clerk, even for bench trials, for jury trials. A lot of the stuff has to be done as part of the pre-trial conference process, but for bench trials, there's no requirement necessarily of the information being exchanged ahead of time. It's helpful to make exhibit binders to kind of keep everything together. Consider out whether there's any other like technology things that you want to use in the courtroom to display evidence. What might be useful for the court. Practice your opening and closing statements. It's always helpful to practice those on non-lawyers to make sure, you're explaining things clearly. They oftentimes have questions and feedback that, you know, is really useful. Practice with your witnesses, particularly your client. It's really helpful to have someone come who's not you to cross your client, so that they're prepared for, and ideally it's someone they've never met before, from your firm, who can kind of play the opposing party and be someone they've never met before, right? Someone who's not necessarily like a face they recognize or feel comfortable with, to sort of like show them what it's going to be like, if they're on the witness stand.
Red for the city. I'm going to be talking about subsidized housing. I need to find my slides. I'm sorry. So, here we go. So we're talking about 3 different types of subsidized housing. The first is public housing. Okay. Yeah, so public housing, and we're going to talk about how different laws apply to people who are in different kinds of subsidized housing when a landlord is seeking eviction. So the first is public housing. This is housing that's funded by HUD and is administered by the local housing authority, which here in DC is DCHA, the DC Housing Authority. And in order to evict someone and terminate their subsidy, they have to actually go through a regular landlord-tenant process. They can't just terminate the subsidy. A person has to be evicted, and that would result in the termination of the subsidy. There is, again, because the subsidy is terminated and the situation with public housing and subsidized housing in the district is so dire, meaning that there is very little of it, and there is really no waiting list that people can get on. It's very important to consider, when you have a case where someone lives in public housing, whether or not it's a good idea for them to move out, because they lose that subsidy and they're unlikely to get it again in their lifetime. The second kind of subsidized housing is site-based Section 8. The sort of regulatory or scheme of this is that it's owned by a private landlord, so not the DC Housing Authority, but HUD pays the landlord the difference between 30% of the tenant's income and the fair market rent for that particular building. And in order to evict someone, ordinarily the procedure would be the same through the landlord-tenant court process. However, in site-based Section 8, the landlord can terminate the subsidy and raise the tenant's rent to market rent. That happens when a tenant doesn't comply with a particular obligation of that tenancy. Say they fail to recertify their income, fail to report their income, or other issues that the tenant ends up with a subsidy termination. What happens when the subsidy is terminated in these cases is that landlord will, because the rent is set to market rent at that point, the tenant then can no longer afford it and then ends up in a non-payment of rent situation. Again, eviction results in the loss of that subsidy. So if a person loses, the subsidy is tied to the unit. So if the person moves out, they lose the subsidy and they're unlikely to get into another subsidized apartment within their lifetime. So very important in settling these cases that you do everything you can to maintain those tenancies so that those tenants don't lose their subsidy. Housing Choice Voucher Program. This is a voucher where tenants can take the voucher anywhere they want, mostly anywhere they want. You rent from a private landlord, and again, the tenant pays 30% of their income toward the rent, and the remainder of that rental value is paid by the DC Housing Authority. It is administered by the local DC Housing Authority. There can be a subsidy termination in a housing choice voucher situation. That subsidy termination would be a termination by DCHA because they are the administrator of the subsidy. So a tenant would get a notice from DCHA saying that their subsidy is terminated, and then the tenant has all sorts of fair hearing process, the opportunities that they can absolve themselves of. But once the tenancy is terminated, or once the subsidy is terminated, then the landlord would no longer get rents from the DC Housing Authority. So that portion of the rent would then fall on the tenant, and the tenant could be evicted if they can't pay that full market rent. So when DCHA wants to terminate a housing choice voucher program subsidy, they would have to give the tenant a notice. The tenant has an opportunity to have an informal hearing. And then if they don't like the decision of the hearing officer, that they would then go to the director of the agency on appeal, and finally appeal ultimately to the DC Court of Appeals. So any strategy that you're working up, oh, I'm sorry, I did not advance. So this is the housing choice voucher program termination. One thing I'll note is that eviction for a serious lease violation is a mandatory ground for terminating subsidy. So say a landlord brings a case against a tenant for a lease violation of having unauthorized occupants. Well, that's not a great example. Let me use the drug related activities in the apartment. If the landlord then sues the tenant in landlord-tenant court because of drug related activities, then if DCHA gets wind of that, then they will terminate the subsidy because it is a violation. It's a mandatory violation. It's also, if a tenant gets evicted, the actual eviction process goes through. That also is a mandatory termination of that subsidy. And again, waiting lists are closed, vouchers are almost impossible to get your hands on. So in working up any of these cases, you want to ensure that you're considering whether or not the subsidy could be lost. Again, vacating the property, if it's public housing or site-based, you lose the subsidy. Again, judgment or eviction carries its own risks for all programs. As I mentioned, the drug-related criminal activity creates a bar to readmission. So that would be for 3 years. For the voucher program, judgment or eviction can result in the voucher termination. And that's what I was just mentioning. They have no discretion in those cases. So the tenant is going to lose their voucher if they're evicted or get a judgment against them. So make sure you counsel your client about the issues surrounding the loss of subsidy. So the HAP contract is the contract between DCHA and a landlord in a voucher situation. So as you can see, there is a lease between the landlord and the tenant. There is a public benefit between the tenant and DCHA. However, the landlord and DCHA do have a HAP contract, which is the contract for payments from DCHA. There's a common scenario in these voucher program cases where DCHA can terminate the tenant or terminate the landlord. So under this program, landlords are required to keep apartments up to what they call housing quality standards. If a landlord fails an inspection, DCHA typically inspects once a year. If the landlord fails that inspection, then DCHA can terminate that payment to the landlord. And then what happens is if the landlord's no longer getting that payment, they sue for DCHA's share of the rent. And so the process for that termination, again, they're supposed to inspect every other year. Sorry, they've moved it to every other year. There will be an initial inspection where they cite the violations, then they'll return 30 days later. If the landlord fails the second inspection, DCHA will stop the payments. And then if a landlord does want to get back in the program or get those payments turned back on, they can request a third inspection, but they have to pay for that third inspection. There is a possibility where a tenant could be terminated for tenant-caused violations. Say the tenant just caused damage, holes in walls or carpet damage because of tenant's negligence. DCHA can terminate based on tenant-caused housing quality inspection violations. Let's see. So if a landlord refuses to pay for that third inspection, the tenant can request that inspection and not have to pay. If the repairs are minor, the tenant can also consider making the repairs on their own in order to reinitiate the payments to the landlord. If the parties are already in court, the tenant could file a motion requesting that the court require or enter an order for the landlord to make those repairs. And so that would be, and you can also request an extension of the third inspection from DCHA if a tenant files that motion to require or to have the court issue an order that the landlord's required to make the make the payments. If the landlord is terminated and isn't reinstated through this third inspection, first, second, or third inspection process, the parties can lease up in place, like create a whole new HAP contract. But you would still have to pass that inspection. So you would get a new lease, and then DCHA would still not be responsible for those payments that were missed while the apartment was not in good condition. Okay, so you may be asking or wondering if DCHA stops payments to the landlord because of housing quality standard violations. Who's responsible for the rent? There is no settled law in DC. There is some case law from other jurisdictions that say no, that the tenant is not responsible for that. There is some language in the CFR that's helpful for tenants if this happens. We ultimately, I think the court will balance the equities here and make a decision. You know, how long should a tenant take to move if the HAP is terminated? If the tenant is there for a year, is that too long? If it takes the tenant a couple months, should the landlord be required to eat that because it was the landlord's malfeasance that ended the payments? And so you really just have to argue that the tenant should, you know, have an opportunity to move, but not be required to move immediately because it was the landlord's fault that the HAP got terminated. Another thing to consider, so we talked about Bell hearings earlier. So in a situation where a landlord has terminated the HAP contract, the landlord will likely ask for a protective order. So that's the order to pay the rent into the court registry until the case is over. Because the tenant had only been paying according to their income, they've been paying 30% of their income. But if the HAP is terminated, the landlord may ask for a protective order at that full HAP contract amount, not just the tenant's portion. Let's see. And so we always argue that the tenant should not be required to pay anything other than their portion of the rent. Because again, it was the landlord's malfeasance that resulted in the termination of the HAP contract. So typically we file a brief in these cases ahead of the Bell hearing so that the judge knows the issues before you get to the Bell hearing. But ultimately the argument is that it's the landlord's fault and they shouldn't get the tenant shouldn't be required to pay the full HAP contract amount as part of a protective order. So rent abatement and intervention. So for tenants, sorry. That's Bell hearing issues. rent abatement and intervention. So for tenants receiving a subsidy, any abatement of rent is calculated from the entire rent amount. That is the full HAP contract amount. It applies whenever your client seeks an abatement that involves subsidy providers' payment, paid rents or payments. So the same idea, you're asking for the landlord to return to the tenant or abate the rent from the full contract rent, not just the tenant's portion. And the basic idea is that the landlord should not benefit simply because the tenant doesn't pay the full market rent. The tenant must, or the court must, notify the subsidy provider. So typically what we do is we send a letter to the subsidy provider saying, this tenant has asserted housing code violations as a defense or a counterclaim in this case. You pay part of the rent in this, and for this apartment, we're giving you the opportunity to come into this case and litigate whether or not you should have money returned to you because the landlord failed to maintain the apartment. If they do intervene, then the tenant and the subsidy provider will get proportional abatements based on how much they pay. If they do not intervene, then they do not get anything. So if the tenant is able to recover on that full market rent. Let me see if I missed anything here. If the tenant litigates this case, say they go to trial and the subsidy provider has become, has intervened in the case, but they sit there the whole time, don't cross-examine any witnesses, don't make any open statements, just sort of sit there and get the benefit of the tenant litigating the case. There is a case that where DCHA was ordered to pay reasonable attorney's fees to legal aid because they didn't participate in the case, and they shouldn't just get all this money based on legal aid's hard work in trying the case. So again, you invite the subsidy provider to become part of the case, and they can file a motion to intervene. There is no clear deadline, and if you fail to send that letter, or they are not notified, it is ultimately the court's responsibility to ensure that they are given an opportunity to come into the case. In these cases, I haven't seen DCHA intervene in years, despite being offered the opportunity. I would say that the last case they intervened in that I've done was in like 2005. So I don't think they're planning to intervene. I don't know if anybody's seen more recent cases where they've intervened. There was a period of time where HUD was intervening in the project-based Section 8 cases, and U.S. attorneys were spending their time on these cases. I haven't seen that in a while. So I just don't think it's not worth their time, frankly. But sometimes you get an eager attorney or an eager branch chief who wants to come in and litigate these cases. The one thing to think about if they do come in is how settlement affects the case. I will tell you the one case I had, DCHA, they were going to pursue the case through trial, but if we settled before trial, they were going to let the tenant take the windfall. So they weren't really going to insist on their portion. So ultimately, they did not get anything through that case because we settled. But if it went to trial, they certainly could get some, or you could get an aggressive attorney, counsel from DCHA to who wants to get their piece of the pie. Let's see. So just talking about how the rent abatement would work if they intervened. So say the contract rent is $1,000, the tenant pays $100, the subsidy provider pays $900. If the judge or the jury award 50% abatement, if entire rent is abated, the reduction is to $500. If only the tenant's share is abated, the reduction is only $50 a month, and the landlord would essentially get a windfall of $450. But if tenant gets to keep the entire abatement, the windfall, the tenant is $450 a month. That's sort of a good example of how these cases could work out if the subsidy provider decides to become part of the case. The last piece I'll say is that if the tenant is sued for rent that the subsidy provider should have paid, so DCHA is a troubled agency. They don't always do things the way they're supposed to, and sometimes they miss payments or mess up in some way. And also sometimes we argue that they wrongfully terminated someone from the program and that person's payments should be going forward. So we typically file a motion requiring them to be joined as a necessary party to seek complete relief in the case. So you have to file that motion at the initial hearing or within such additional time as the court may allow for good cause. So it requires you to work up the case pretty quickly if you need to file that motion for the initial hearing. Good cause, I haven't had to file one of these, so I'm not sure how the court would rule on these good cause motions. I think the court is pretty lenient if you can make the argument that, you know, you were just retained and the tenant didn't know they had to do this, or some other good reason as to why that motion wasn't filed right away. Discovered new evidence that you know led you to believe that the DCHA should be or HUD should be required to be joined. If the landlord-tenant court grants the motion, you are going to be required to serve the party that is to be joined. So essentially, it's like you initiating a case against that subsidy provider, and then you have to file the proof of service at least 6 days prior to the further hearing. Yeah, so bringing them in, and I'll just tell you a quick story. I had a client who we believed was wrongfully terminated from the voucher program. And we brought DCHA into the case through one of these motions. And ultimately, we're arguing the wrongful termination of the subsidy at DCHA through their hearing process. And also litigating the case in landlord-tenant court because the landlord wasn't getting payments from DCHA because they had terminated my client. We ended up ultimately settling, but DCHA became part of the case and strenuously argued that it wasn't their fault. But ultimately, it resulted in my client being reinstated in the program, DCHA making the back payments, and then it resolved the landlord-tenant case because DCHA made up all the payments that were missed. So these cases are definitely winnable if you can argue that DCHA is a necessary party and that they are the ones who screwed up the payments. That's all I have.
Where to start? All right, so starting off with, when are your opportunities to negotiate? Basically all of the time. You can do it at the initial hearing or before the further initial hearing. Although this is generally not recommended, just because at this point you will have the least amount of leverage and before the merits of the case are clear. It's also with most of the landlord's attorneys appearing remotely. Even if you are in person, there's not going to be a lot of opportunities to negotiate. But you can absolutely try to negotiate either if you think you've got leverage or if there's some specific matter you want to negotiate, such as resolving motions, particularly motions for protective order or Bell hearings. As previously stated, landlords' attorneys do not want to have actual hearings, so you can often work out an agreement in advance, but also motions for sanctions, motions to court orders, other agreements. Obviously at mediation, that's your big opportunity to negotiate at a pretrial conference if you have a jury trial, and then generally throughout the process of litigation. So in a bench trial case, mediation is set by the court at a date prior to trial. It's usually at least a few weeks before the trial date, but there is no standard timeline. If you have moved for discovery, in a bench trial, you should ask for a mediation date that's will allow discovery to be completed. You are required to attempt mediation and attend mediation. It is taking place through the multi-door dispute resolution center. This says that mediations are currently remote. That is the default right now, but you can ask for an in-person mediation. You and your client, if it is remote, you'll need to sign an agreement to mediate and return it in advance of the mediation. If it's in person, they'll have it at the mediation date. And if your client doesn't speak English, they do have translated copies of that agreement available. Jury trials. Mediation is scheduled several months after the jury demand is filed. Typically, it's after the close of discovery. It's helpful to advocate for at least 2 weeks after the close of discovery, so you can resolve any discovery disputes in advance, although in my experience, the court usually automatically does this, but it's good to make sure. There is technically a rule that you're supposed to submit a confidential settlement statement in advance on the court form provided, where the defendant, your job is going to be describing the facts and defenses being raised, as well as any counterclaims, and asked to assess the value of the case. In my experience, this is usually not actually required, as in you won't get in trouble if you don't submit this, and neither will the plaintiff. However, it's a good idea to have this done anyway, because this is what you should be knowing prior to going into mediation regardless. And
Thank you, Sarah. So now we're going to talk a little about a key concept, redeemable versus non-redeemable judgments. Redeemable judgments are in non-payment rent cases where, and that's the default if the landlord prevails in a non-payment of rent case. It means that the tenant can redeem the tenancy or translux, and what that means is if the tenant pays whatever the is allegedly owed before a judgment is entered, or now that we're talking about like with a judgment entered, after a judgment is entered, they pay whatever the court says that they owe, depending on whether it's on the merits or because of breach of a settlement agreement, then they can pay that to avoid eviction. And so with redeemable judgments, the redeeming is paying what is owed to stop the eviction process, depending wherever that eviction process is. So this is appropriate in a settlement agreement that is a case about money. Even if filed as a lease violation case, it is possible that maybe there would be a redeemable judgment as part of the remedy that the landlord has to resolve the case. And the redemption amount can not include late fees or other non-rent fees unless the parties specify in settlement that they can be included in the agreement. Non-redeemable judgments, and here we're talking about judgments for possession. So just to take a step back, when we were talking earlier in civil procedure, like one of the key remedies, the key remedy that a landlord can obtain in a case is a judgment for possession, which means the judgment to be able to remove someone from the home, to kick someone out of their home. And so that's what we're talking about in terms of redeemable or non-redeemable. So non-redeemable judgments, those are breach of lease cases or obligation of tenancy cases, or basically every kind of eviction case under the Rental Housing Act that is not a non-payment rent case. The remedy would be a non-redeemable judgment because redeemable only applies in non-payment rent cases. And this type of judgment is irreversible unless there's some other way to get out from under it. But if it's in an agreement, then it might be difficult once it's entered to challenge that. There's other contexts, like if there's been a default judgment entered or something like that, they can often be reversed. But in a settlement agreement, there isn't an option to pay and stay. And so I just want to emphasize that a non-redeemable judgment, that if it's a case that involves non-payment of rent or payment of rent, that to be really careful about having a non-redeemable judgment be the remedy that the landlord is entitled to if the tenant breaches the settlement agreement. So non-redeemable judgments as a penalty for breaching a settlement agreement guarantee the judgment and eviction as long as the landlord can prove a material breach occurred in the agreement. And as I just said, especially in non-payment rent cases, a non-renewable judgment should almost never be a penalty in the settlement agreement unless the tenant is agreeing to vacate. So it's a move-out agreement where it's much more it's more common and it's not really harming the tenant's interest to have a non-renewable judgment in the context of a move-out agreement. And I'll pass back to Sarah.
All right. So in a non-payment of rent case, what does a typical settlement look like? Most non-payment rent cases are going to be settled with some sort of abatement or waiver of outstanding non-payment of rent claims. If at all possible, you don't want to be just having your client agreeing to pay back the full amount of whatever was owed. You should prepare your calculations in advance. You should take account of the alleged non-payment of rent and the value of any defenses or counterclaim to calculate a percent abatement over a relevant time period. So you can present it to the opposing party and argue why the amount of the abatement that you are requesting is appropriate. You should include the full counterclaim period, and also remember, and this is important, that recoupment has no time limit. So if your client has been living in the building for a past decade and they've had housing code violations in their unit the entire time, you can request an abatement for 10 years, which can add up really quickly, even if it's just a small abatement. But also remember to account for prior judgments and subtract those months. When you're calculating this, consider what would be required for your client to owe zero and what would be required for them to owe zero, and then get all or part of the funds in the registry back to them. And to keep in mind when you're doing this, that the landlord is likely going to be more willing to waive the rent or let go of funds in the registry because that money is not yet in their pocket. It's going to it feels different to write a check. So if a tenant still owes rent after whatever, all of the abatements that you've calculated or that you can agree on, you're going to want to then include a reasonable payment plan. Be creative in writing these. For example, you could put as part of a condition that the tenant will apply for emergency rental assistance. But make sure you can put in a provision that the landlord has to cooperate with the application process and accept a reasonable payment plan if that assistance is denied. When you are setting up this payment plan, you need to make sure you have a very candid conversation with your client to make sure it is actually realistic. This is especially important with clients who are living in subsidized housing because their income is very, very low. And you want to make sure that they understand that they will need to make these payments and are going to be able to reasonably make these payments going forward. And specifically, if you're looking for an amount in public housing and site-based Section 8, repayment agreements should be limited to 10% of their adjusted household income. This is worth trying to negotiate for in other subsidized tenancies as well. If you're doing a repayment plan and you think your client's income might change, you can also try to build a provision into the settlement agreement to account for that. The landlord is almost always going to request the tenant pay future rent on time. You should try to fight this as much as possible and see if you can get it out. The other thing that you can include in a settlement is a list of repairs to resolve remaining issues. You're going to want to discuss what repairs your clients want done and ensure that they will provide reasonable access to the premises for repairs. You can include information about access and the processes for providing that access in your settlement agreement. You might want to specify that the repairs will be workmanlike or include verification and inspection procedures if you think that that might be an issue. And then when you're coming up with this list, because it's a settlement, independent contract, you're not just limited to housing code violations. If your client has other concerns about the conditions in their unit, such as replacing the carpet or repainting other parts of the unit, and you can include those as well. You're also gonna wanna think about enforcement mechanisms. Obviously, the landlord is going to want a judgment if your client doesn't comply with the agreement, but you can have enforcement mechanisms built and should have enforcement mechanisms built into the agreement as well. You can, for example, you can build in a term that your client has can miss a certain number of late payments before the landlord can file a motion. You can request a longer notice period for the motion if you're going to be continuing to represent this client. For example, normally they have to serve you, there's a notice period of 7 to 10 calendar days. You can request 15 business days, though again, realistically right now, those time periods are considerably longer. But you can also make sure they send you a notice, copy of the notice, and not just send a notice to your client and then hope your client shows up, receives it and shows up. For your client, or if you've included repair provisions in your settlement agreement, it's typical to build in a provision that your client should be able to file a motion seeking specific performance. So a motion, an order to compel repairs. But you should also consider enforcement mechanisms that might allow your tenant to pay into the court registry until repairs are completed. That your client may be able to demand a hearing on the who gets that money if the repairs are not timely completed. And this can either be a continuation of the payment into the court registry or a provision that the tenant can start repaying into the court registry once a motion to enforce repairs is filed. You can also build in specific rent abatement penalties into the settlement agreement. And back to Paul for lease violations.
Thank you, Sarah. So when we're talking about lease violation cases or violation of obligation of tenancy cases, most of these cases are settled with the dismissal of claims or a good conduct agreement, or where necessary, a vacate or move out agreement. And it is true that often in these cases, once the costs of these cases start building up and perhaps potentially the landlord or their attorney realizes how difficult or impossible it will be for them to actually prove their case, then they may just dismiss it on their own rather than continue with proceeding with the case. But, and so really it is important to consider, like when you're counseling your client and considering how to approach negotiation, and think about dismissal. When dismissal makes more sense if the landlord does not have evidence, either a violation itself or failure to cure the violation, or if the tenant has reasonable accommodation or other complete defense, or another, basically an argument for why it doesn't even really matter whether they violated the obligation of tenancy and failed to cure, or if the tenant is willing to bar the person who is the problem, or to not allow that person who is the problem to enter the home, or potentially just not have them be part of the household as opposed to necessarily barring them. You know, there's lots of different options in terms of how the terms might work out in these kinds of agreements. Another possibility is, especially if there seems to be a higher risk of potentially the landlord being able to prove their prima facie case and prevail on the merits. And this is, and going back to the civil procedure, this is where also discovery can be really important in determining the likelihood of that being the case, is considering whether a good conduct agreement is possible. And by good conduct agreement, it's this sort of agreement in which the tenant is agreeing to not take some kind of action, which could be defined very broadly or very narrowly, depending on the scope of the agreement, and also the time period and whatever the remedy is for that agreement, which we'll talk a little bit on the next slide. But in part of this, you want to have an early, frank discussion with your client about their ability to comply, including conduct by other household members and guests. So whatever kind of conduct they're agreeing to do, it's important that your client and their household be able to comply with whatever they're agreeing to do. Otherwise, it's setting them up for a bad outcome. And so going to these considerations in a little bit more detail. So time period. Oftentimes 6 months to a year, potentially you might be able to get less. Again, it also really matters what these other factors are in terms of what kind of settlement agreement and what makes sense for your client and what they feel comfortable with. but more than a year can be very difficult for someone to comply with, unless it's something that's, and creates more risk. It means more time that if they or their household do the prohibited conduct, they can be facing eviction if it's for the longer that time period is. So really limit it as much as possible. In one strike cases, or these are cases where the tenant doesn't have has a right to cure because they're in fairly subsidized housing and the lease has language in it that prohibits this kind of conduct and incorporates the federal law related to what not being able to cure the provision. And if the case, doesn't look that great in the merits, then potentially you might do a longer agreement in those kinds of cases. And also defining behavior, trying to be as specific as possible. Instead of no noise or say lease violations or something really broad like that, try to say something like no music after 10 p.m. or not doing a specific act. So really making it narrow. And again, this is part of having the conversation with the client about like what they feel they and their household can do or cannot do. You really don't want to set up your client to violate the agreement late down the road. And also consider how difficult, how broad or general the agreement is in its terms, and how difficult for the landlord to prove breach and for the tenant to defend against the alleged breach. Again, describe the prohibited conduct as narrowly as possible, define how the landlord can prove, and define how landlord can prove the breach. In terms of enforcement mechanisms, it is typical for a landlord to be able to file a motion seeking a non-redeemable judgment for an alleged breach of a good conduct agreement. But there's a lot of options in how the remedy might actually work out, which can be put into the terms of the agreement. So, for example, in the agreement, you can request a longer notice period for the motion. Maybe, I think that right now, oftentimes motions will be set farther in the future than 15 days, but you could set a longer time period than would normally happen. You could talk with your mentor about exactly what would make sense in that context to give you more time to prepare for that. What might really be ultimately almost like a trial will be a hearing about like whether or not the agreement was reached, and will potentially lead to your clients being evicted. You could also ask for informal discovery as part of the motion process, or even just discovery. You could agree to all kinds of things in terms of an agreement. So you ask for witness lists, produce any evidence that will be used at the hearing, and describe the alleged breach with specificity. And if possible, you can build a notice and a short opportunity to cure before the landlord can file the motion. And really, this is a place that you could be creative, right? Like, especially if like you could see what the landlord will go or not go with, but certainly creating more protections for your client and making the process more onerous for the other side can help get a better result and avoid there being any kind of breach or risk of eviction in the first place from the settlement agreement. And I'll pass back to Sarah.
All right, move out agreements. Move out agreements should be the last resort for all cases, especially subsidized housing cases, as you have heard before, and we really want to drill home. The tenant may lose their subsidy after moving out, especially if it's public or site-based housing. So you really want to make sure you explain the consequences of a move-out agreement to your client, especially in those circumstances. You shouldn't agree to a move-out agreement before fully assessing the case merits through both discovery and just fact gathering on your own. And don't do it just based on your client's gut reaction to a desire to leave the apartment until you assess the feasibility of leaving the apartment. You want to consider how long will it actually take on a practical level. Again, if they have a Section 8 voucher, there's time constraints outside their control. But even if they don't, it's not that easy to find new housing in DC, especially if you're low income. You need to figure out what it will cost, where the client will go, and what their backup plan is if they had a plan to move out by a certain date and that plan falls through and their move out date is approaching. So it's really important to assess move out agreements very carefully before agreeing to anyone. Remember that the expiration of a lease is not grounds for recovering possession of the apartment. If a landlord tries to raise this, that's bogus, and there's not much more to say about that. And then, again, be realistic with both yourself and your client about the actual costs and the timing of moving. So what does a move-out agreement look like? Landlords may request a consent judgment with a stay. This means that the judgment would be entered against your client, but it would be stayed until after the vacate date. You should not agree to this unless you absolutely have to, because once a judgment's entered, that limits, or once a judgment is entered, you don't have any more ability to fight it if your client doesn't move out. You should instead require the landlord to file a motion seeking a non-redeemable or redeemable, depending on which kind of case you have, judgment, again, with special notice provisions so that you get that judgment right away. And you should request a hearing if possible. Make sure that's in your agreement. You can also schedule a status hearing you can request several days to a week. It likely won't be granted, but request a status hearing for some time after the vacate date. And at that hearing, if your client has vacated, then the claims will be dismissed. And then if the tenant has not vacated, the landlord can receive a non-redeemable judgment for possession at that hearing. The advantage of setting the status hearing can be that that way you don't have to worry about either you or your client not being properly served or not receiving that notice of motion from the landlord to seek a non-redeemable judgment. And again, you should never agree to any process where a judgment's entered or a writ is issued automatically. You want a chance to raise defenses and to make the landlord actually prove that your client has not in fact vacated. Some other terms that you should consider including in move-out agreements: waiver of rent, late fees, and all other charges on the ledger, return of the security deposit, and other pre-move, and also see if you can get any pre-moving payment to help with the first month's rent and security deposit of a new unit. Again, how willing a landlord is to agree to that is going to depend on the facts of your case, and how hard you can argue for it will depend on the facts of your case. You should consider if the funds in the court registry could be released for that purpose. Again, it's not money in the landlord's pocket, so there'll be more. They are often more willing to release that. And then if the landlord's not willing to make a payment, ask if the landlord will waive your client's share of the rent until they vacate. So if your client has 60 days to move out, build in a provision that their rent will be waived for those 60 days. You can also request or should request that there be a provision for a neutral rent reference for your client. That means that if requested, the landlord will only confirm the dates of the tenancy and that your tenant vacated voluntarily and that there were no amounts of money owed. And then if appropriate, you might want to include a provision on the specifics of how and when the client will surrender their keys to a landlord, especially if there is tensions in the relationship between a property manager and a tenant, as there very often are in these cases. You want to make sure everyone knows what is supposed to happen and when. And back to Paul.
Thank you, Sarah. And I think just on that last point that Sarah made, like, I think oftentimes thinking of the terms, if you anticipate that there might be an issue with something or like an ambiguity that might cause problems that might impact your client negatively, that's often, not always, like potentially you might try to be ambiguous intentionally to try to get something in an agreement, but often it's helpful to be more specific to avoid that problem happening in the first place. And again, that's something to think strategically about and talk with your client about and talk about with your mentor about, but that's a great point in terms of agreements. So in terms of the form of an agreement, there are form agreements published by the court. These agreements are not generally favorable to tenants. And each unique case deserves its own unique settlement agreement. And so often, you should be drafting these agreements, and it's great for you to take the lead on. Often, as you've maybe already gathered, plaintiffs' attorneys are not necessarily the most energetic bunch about doing things, and they have a lot going on, and they don't necessarily have the skills to do it. So for those reasons, often they'll let you just draft something if you let them, and that could be really helpful in getting terms in that benefit your client. In terms of writing your own agreement, again, you're always free to write your own agreement and have to use court forms. So just there to help pro se parties or help landlords hurt pro se parties, but something like that. And when preparing for mediation, if possible, draft agreements in advance and bring it with you, even if you have to fill in the blanks. That'll just help set the tone for the, like, in the way that you want in terms of negotiating with the other side. This will give you time to work through issues in advance, carefully choose your language, and have someone else review it without time pressure. And you can check in with your mentor if you have it done beforehand. And as we've been talking about already, you can be creative. Are there pretexts, agendas behind other parties' actions? Can your client resolve that issue? Or another way of thinking of it, is there some kind of win-win where you can think about a way to address the other side's needs or goals or interests while advancing your client's goals? Are there remedies that either party desires in which the court can order at the end of trial? We don't have to be part of part of the eviction case. There could be all kinds of things that could be addressed, as Sarah was saying, in terms of security deposit, that aren't necessarily part of what would happen on the merits. So again, you have a lot of room to be creative here. Can you create additional opportunities for your client if your client makes a mistake or has difficulty complying with a settlement? So again, like ways to soften or reduce the potential harm that can happen to them, which includes some of these procedural issues that we could raise. We talked about with good behavior agreements, for instance, and other considerations. Oops, sorry, I did not. Well, anyway, so that was the big creative. Apologies. Some ideas. Consider entering a conditional agreement or one that offers two options. Tenants get emergency rental assistance by X date, or a reasonable payment plan kicks in. So again, by doing something like this, you avoid the potential harm of maybe the tenant doesn't get the emergency rental payment, and then they can't afford to make the agreement. They can't afford the payments under the agreement, and and they risk being evicted. But at the same time, if your agreement does come in, then they take the benefit of that. So this could be a way that you are protecting your client by having different options available in the agreement. Build in second and third chances. So for example, where a landlord alleges housekeeping violations, weave in a test period. And by weaving in a test period, maybe allowing to have some kind of time period where there could be inspections to see about whether housekeeping, how it's going, and to maybe give opportunities to get assistance with that. For example, if maybe someone needs assistance because of a disability or something else with maintaining the condition of their home. Schedule inspections and require a tenant to correct the identify issues with an X days, with landlord will file a motion for judgment. And this is a way of also maybe like giving a heads up to the tenant so they can kind of avoid these issues. And again, you can resolve these matters beforehand. You could set a time to meet before, you could require a meeting before there's a motion filed that could potentially assist with resolving whatever the issue between the parties. If there's an outstanding transfer request based on a reasonable accommodation or safety, and this is, this is in the context, I think, of like maybe of a voucher, like the housing voucher program we were talking about earlier, include reasonable accommodation provision requiring the landlord to cover moving costs if transfer occurs. And now back to Sarah.
All right, so some special consideration for tenants with a Section 8 voucher. This is, we said you could settle at any time in a case, but settling early maybe not be in your client's best interest. For a tenant with a voucher, you may not want to settle early, but you should start preparing for settlement as early as possible in the case. Especially because of the timelines if your client's considering vacating and moving with his or her voucher. Because you might want to, in that case, you're going to want to try to obtain a transfer voucher as early as possible in the case process. Those are valid for 180 days and can be renewed by DCHA later for additional time. But because the new units must pass inspection and the new landlord and client must lease up with the Housing Choice Voucher Program, this process can take several months, even once the client has found a new place. So the earlier you can start on this process, the better. And also a client might find it difficult to find a new place, especially if their voucher is for a larger unit. You heard earlier about the process of inviting DCHA or other subsidy providers into the case. Consider the timing of when you might want to do that. And then I believe the Aging and Disability Resource Center, Bread for the City, Lift DC, and other social services providers may be able to help with a housing search. So if your mentor's from one of those organizations, reach out to them or reach out to your mentor to see if they can contact an organization that might be able to help with that search. And then special considerations for all subsidized tenants is, again, the risk of the loss of the subsidy. Again, for public housing or site-based Section 8, if they vacate the property, they lose that subsidy likely forever. On the other hand, if there's a judgment or eviction against them, that can also carry its own risks. For all programs, if they're evicted for drug-related criminal activity, that creates a bar to readmission to any federalized subsidized housing program for 3 years. So not only do they lose a subsidy, they also can't get a new one for at least 3 years. And for housing choice voucher, the housing choice vouchers, judgment and eviction can result as a voucher termination, as you put earlier. And it's a serious lease violation that's mandatory and not discretionary basis for termination, again, as discussed earlier. So you're going to want to make sure you counsel your client about this and all the alternatives and really take into consideration all of the risks of either continuing with a case or losing the property, and make sure that they are, as best as you can, make sure they're aware of the fact that they are unlikely to regain a subsidy once it's lost, and that they're taking that into consideration in their decision. Oh, post-judgment proceedings, I'm going to turn this back over to Paul.
Thank you, Sarah. So post-judgment proceedings. So in situations where the landlord claims a violation of the settlement agreement, as we've been talking about, I think already, in a settlement agreement, often, especially when you're drafting, there would be the remedy that a landlord would be able to have if there's a breach of the agreement would often be filing a motion. And that usually would be a motion to enter a redeemable or non-redeemable judgment. All such motions are going to be scheduled for an evidentiary hearing in the landlord-tenant court. You're going to remain counsel of record for that hearing. So part of what you'll be doing is preparing for that hearing and potentially, challenging whatever the allegations that the landlord is making about the way that that your client allegedly breached the settlement agreement. And this was, I don't know, I feel like the court is changing its exactly how far out these cases are, like how far they set up these hearings nowadays. But I think it'll be a matter of, what is it, like weeks, maybe a month or two before you probably have it be set?
Yeah, right now they're scheduling, I think, late August.
Okay, so it's months still. Okay, it's still months.
But it's definitely ebbs and flows depending on the court's calendar.
Yeah, and again, it's something that may potentially could affect with the terms of the agreement, but so that's often when it would be set. When the tenant claims a violation of the agreement, again, typical settlement provision will require you to file a motion to show cause or to otherwise enforce the settlement agreement. And this is going to be really set up on whatever are the terms of the agreement that you wrote, right? Like whatever's the remedy that you put in there. So whatever the tenant is entitled to, whether that's enforcing the agreement or potentially also not having to, like, being able to pay money at the court register, whatever other kind of remedy you creatively think of as a way to try to advance your client's goals. And before filing a motion, consider whether informal resolution is possible, especially if there's a way that you can meet everyone's interests. Like there's a way that you could either, whether it's an alleged breach by your client or by the landlord, maybe there's some way that you could resolve this through reaching out. And current slide, questions. Any questions for Sarah or me?
I think at this point, we're available to answer questions about either settlement, mediation specifically, or sort of any other part of what we've covered today before we wrap up.
Are there any hands? Oh, yes.
Are there any settlement templates that we can kind of go off of for prior settlements that we negotiated already? Have some of these clauses in them?
Yes, I think that your mentor would have available to them a very wide variety of templates or examples or former actual settlement agreements that you could use as a place to jump off of. Well, it's not. Well, the court has one that basically says the tenant pays the money, and then there's that pays money, and if not, there's a redeemable judgment entered based on a motion, which is And then there's another one where the judgment's entered already. So yeah, so there's gonna be, like with any kind of pleading that you're gonna be drafting, anything you're gonna be filing with the court, like your mentor's gonna be able to assist with that. And you could also look at pro bono.net for examples. But at the same time, part of what we've been talking through is that while that's a great starting out point, and you definitely, I think that's a great question. You'll want to have that to help you as well as talking with your mentor. It's also for each case, there might be specific terms that you're gonna make up and propose that are going to be great, that are going to advance that specific client's specific interests and goals. But as a baseline, I think, yeah, having different examples and talking different people's stories about different things they got out of opposing counsel in different situations is going to be really useful. Other questions?
I think there was one that I saw one that popped up on the screen.
That was me saying you can put questions in the chat.
Oh, exciting.
Well, thank you so much. If there are no additional questions, you can reach out to Paul, Sarah, any of the folks who have done presentations today, or your mentors when you have when you take cases. Shula and Sylvia, I think I sent out the materials from this already today. But if you think of questions, you're welcome to reach out sort of via any of the various methods of getting a hold of us. And we look forward to seeing folks take on their first or second or third of these cases, as the case may be. So those of us in the room can stick around for a little bit for questions, but to everyone online, thank you so much for joining today. We really appreciate your attendance and look forward to connecting with you another time. Thank you so much. And then I think we can stop recording and